Good afternoon. Part two of today's discussion about regulators, not legal advice. Again, even if you hate the host and the content, if you don't hate kids, like and subscribe. For every 1,000 subscribers, new subscribers, I will donate $50 to the Los Angeles Children's Hospital. So nobody can argue about that. So please like and subscribe. So I earlier provided a video discussing another view on Silicon Valley Bank and regulators, and now I kind of wanted to get into how it applies to Finra and MMTLP, at least a section, at least a look at it. And so the title of this particular video is Regulators Suck. So we just had an example of the gross regulatory mismanagement involving Silicon Valley Bank. And besides the fact of the collapse and now the Chapter 11 bankruptcy, which is a reorganization, not a complete dissolving of the company, I saw Janet Yellen testify in Congress with regard to the issue. I found her very unimpressive. She created more issues than she solved. And the one major point that I threw out was Seeking Alpha in December of 22 brought up that Silicon Valley Bank was in deep trouble. So, what was the Fed, the FDIC doing in the meantime? Why didn't they review the financials? Why didn't they know what was going on? With all appropriate respect to those good regulators, and I'm going to generalize a lot, so understand there's good regulators with good intentions, but I'm talking about generally and the majority. And this is just my opinion. But props to the good regulators. And again, I wish there were more. However, unfortunately, most regulators do not seem to be interested, funded, qualified, motivated, often have conflicts or worse. So I think that has to be understood before we move on. So now I'm going to talk about FINRA and MMTLP. And as you know, I have a lawsuit involving Fidelity, Finra, etc. So I'm going to put that in the context of the lawsuit and give you some background as to why I think Finra is incompetent and sucks. It's going to be the common theme throughout. So FINRA has stonewalled Congress. So my understanding is Congress asked for information related to MMTLP, but FINRA stonewalled them. They've stonewalled counsel. I've asked for various documents. I've addressed the FAQ with them. No response. But I will certainly make my court aware of their failure to respond, what I see as stonewalling, and issues regarding the FAQ. In their FAQ, their defense, in my opinion, is that they seem to suggest that the defense is that they were incompetent. And I'll get into the reason why that's the defense they chose. However, and I'm not going to get into this, but it will certainly be before the court, I think inadvertently or intentionally, what they put in an FAQ suggests criminal conduct. And it's unrelated, as far as I can see, to naked shorting. And it also seems to implicate the brokers. So again, that's what it seems to me. Some lawyer might make an argument about that, and some judge might be convinced about it. But I can't really get into specifics now, but I'm sure it will become more apparent later on. So note this video is a permanent record to all in Congress. And the reason why I'm saying this, because we just had an example with Silicon Valley Bank. So I'm telling you, unless you intervene at some point in time, we are going to have a disaster. And this is a record of that. And if a disaster ensues, a financial disaster, because you did not take action, you will suffer the consequences. So one thing really, I want to make sure everybody holds Congress, Senate, all politicians responsible for not acting as they should. This is not a surprise anymore. Everybody is aware of this. If you don't act now, it's on you. So I did see what I call a pile of crap, the FAQ. It took them 100 days to prepare that. And that was the best, apparently, that was the best they could do. So I was thinking about that. So that means all their executives, all their inside and outside counsel, their accountants, and whoever else, whatever experts, spent 100 days to prepare that. Really? Why even put that out? The fact that you put that out at this time with that quality and basically admitting you were incompetent is further confirmation that regulators suck. The work product they put out to defend the indefensible is purely garbage. On top of that, they offer no solutions for MMTLP. But beyond that, they offer no solutions for their admitted failures. How are they going to fix the purported coding issues, which coincidentally involved MMTLP and shorts? Wow, what a coincidence. Why do you believe, and this is the part I was trying to figure out, why would they do this now? Why in this form? And why do they believe that admitting incompetence would provide them with more credibility? So why, if they are admitting they're incompetent, why would that make me believe anything else they told me? I don't understand that. I'm not going to get into the details again, but the court will have all the details when my opposition is filed in about 10 days. The FAQ, in my opinion, this is my read. The FAQ is designed with the intention of limiting Finra's exposure in a legal fashion. And this is not legal advice, of course. Since Finra believes it's immune for misconduct undertaken in its regulatory capacity, their admission of incompetence, they believe, will fit within that immunity. So even though they should be ashamed and embarrassed, and the entire executive staff of Finra should be fired along with the CEO, Robert Cook, who apparently receives in excess of $3 million salary per year and who knows what other favors. But they believe that admitting incompetence is acceptable. Finra is a scam, a front for those who influence and control Finra and the financial industry. It's an embarrassment to this country. And as we've seen with Silicon Valley Bank, it's the regulators who are not preventing the systemic failures in the country. Ultimately, the bailouts of any sort are inflationary, so it costs us all money for incompetence and worse of the people who are supposed to work for us. The same argument applies to Congress and the White House. If they're not interested in protecting citizens, then F them and tell them so and publicly embrace those who accept and will protect us, the retail. Now, going back to Finra again, their defense in the FAQ, we made errors, we are incompetent, it's the broker's fault. Because again, they are seemingly immune, or they believe they're seemingly immune for acts, even incompetent acts, within their regulatory capacity. However, what they have somehow missed, that based on the FAQ and admissions raised in the FAQ, that they have admitted, in my opinion, to engaging in criminal misconduct, and admitted that the brokers did too, without having to address the issue of naked shorting. Most of this will follow in 10 days, but I can only imagine counsel for Finra, in my case, outside counsel, who apparently was not involved in the drafting of this document, must have seen it when I did and must have passed out. So again, you'll know more about my specific take in about 10 days, but I have to thank Finra for giving me the additional ammunition and to giving the community additional ammunition. So last but not least, let's go to the punchline. And this is going to be a trick. So I'm telling you right now, this is a trick. So listen very carefully. You will understand my point at the end, and you'll understand the rant above when I'm done. So this is one of those articles that I read. It's done by Helen Avery, and it happens to deal with naked shorting. And the premise of the article, coincidentally, is that small companies believe that they're being squeezed by naked shorting, with their share prices being forced down. And coincidentally, the brokers, clearinghouses like DTCC, market makers, all dismiss this as rubbish. The article focused on the case of Robert Simpson, who decided to buy the entire stock of one OTC company called Global Links. He paid $5,000 for 1.285 million shares of Global Links. These shares, the entire float, were then put into Mr. Simpson's account. The following day, 37 million shares of Global Links were traded on the OTC. The next day, 22 million shares were traded. It also turned out that Simpson had actually purchased about 128,000 more shares of Global Links than actually existed. Simpson believes that his other company, Zon Corp, which has plummeted over 98%, is being naked shorted too. The article suggests that, as we know, small and risky stocks are targeted for naked shorting. Many are struggling young companies that can be easily derailed. Companies like Microsoft at one point in time were $16,000 companies. So any company can be derailed and the impact could be dramatic. There are claims in the article that naked shorting began way back in 1981 and facilitated by deficiencies at the DTCC. The article specifically deals with the stock borrow program facilitated by the DTCC. The article then goes on to indicate that the stock borrow program often creates duplicative shares, as we know, dilution, borrowers of those shares not having to close them out, etc. NanoPierce Technologies, a small company, claims that the stock borrow program caused a gross manipulation of their stock price. But the article then goes on to, with a point of optimism, the article, and we're coming close to the punchline here, the article goes on to say that the SEC is proposing or has just issued new guidelines to prevent naked shorting, and things should be substantially better in the future. So the date of this article is March 28th, 2005. So don't let the regulators off the hook. They are incompetent, do not correct deficiencies, do not care, and do not take responsibility. Do not let your politicians off the hook for letting this happen. Support their opponents. Again, I'm generalizing as to regulators, but the facts are the facts. Have a good Sunday. Keep up the good spirit and the efforts.